Hello, this is Barrister Garn from Siam Center Law Group. Many people agree to act as a guarantor for a family member, a close friend, or a business partner because they simply want to help. At the time of signing, they often believe the borrower will make the payments as agreed and that the guarantee is merely a formality. However, when the borrower defaults, becomes unable to pay, or even disappears, the creditor may turn directly to the guarantor for payment. This situation causes many guarantors to panic, fearing that they will immediately become responsible for the entire debt and risk having their assets seized or their income garnished. The good news is that Thai law does not leave guarantors completely unprotected. In fact, there are several legal rights and defenses available that may reduce liability or provide practical solutions. Therefore, if you receive a demand letter, a collection notice, or even a lawsuit as a guarantor, it is important not to panic and not to assume that you must automatically pay everything being claimed. Instead, you should carefully review the facts and legal documents before deciding how to proceed, because in many cases, a guarantor has more options than they realize. The first step is to carefully review the guarantee agreement itself. You should check whether it properly specifies the guaranteed debt, the amount, the duration of the guarantee, and whether all legal requirements have been satisfied. It is also important to determine whether the creditor has complied with the procedures required by law, such as providing proper notice of default when applicable. In addition, a guarantor is generally entitled to raise many of the same defenses that are available to the borrower. For example, the debt may be invalid, already paid, subject to unlawful interest charges, or barred by the statute of limitations. In some situations, a guarantor may also request that the creditor first pursue the borrower's assets or enforce other available security before seeking recovery from the guarantor. If the legal defenses are limited, negotiation may provide another effective solution. A guarantor may be able to arrange installment payments, negotiate a reduction of the debt, or reach a settlement that minimizes financial damage. Most importantly, if a guarantor ultimately pays the debt on behalf of the borrower, the law grants the guarantor the right of recourse, meaning the guarantor can later sue the borrower to recover the amount paid and may enforce a judgment against the borrower's assets in the future. For this reason, being a guarantor does not mean you are helpless or without legal protection. The key is understanding your rights, knowing when to defend a claim, when to negotiate, and when to take legal action to protect your own interests under the law. Thank you for watching. If this content was helpful, please like, share, and subscribe to our channel so you won't miss our upcoming legal content. For any legal questions, or if you'd like us to cover a specific topic, feel free to leave a comment or contact us anytime.